Question 1. Topic: Hearsay and its exceptions. 3801 and 803. In a high-stakes environment where multiple challenges arise, a criminal trial involves a key witness who refuses to testify due to fear of retaliation. However, the prosecution seeks to admit the witness's prior statement given to police officers under oath as evidence. The defense objects, arguing that this constitutes hearsay. Under the federal rules of evidence, is this statement admissible? A, no, because the statement is hearsay and does not fall under any exceptions. B, yes, because it qualifies as a prior and consistent statement under 3801D1A. C, yes, because it is admissible under the former testimony exception 3804B1. D, no, because testimonial statements require the witness to be available for cross-examination under the confrontation clause. Answer: C, yes, because it is admissible under the former testimony exception 3804B1. Explanation: the statement in question is hearsay because it is an out-of-court statement offered for the truth of the matter asserted 3801. However, it may qualify for an exception. Under 3804B1, a prior statement is admissible if the declarant is unavailable. The statement was made under oath. The opposing party had a prior opportunity to cross-examine the declarant. Here, the witness is unavailable due to fear. 3804A2, and the statement was given under oath to police officers like it is part of a formal proceeding if the defense had an opportunity to cross-examine the witness at a hearing. This exception applies is incorrect because hearsay exceptions exist and this situation fits within one. B is incorrect because prior and consistent statements are only admissible under 3801D1A if made at a prior proceeding and the declarant is available for cross-examination. D is incorrect because while the confrontation clause, Crawford v. Washington, 2004, requires the ability to cross-examine testimonial statements, prior testimony that met cross-examination requirements can still be admissible. Question 2. Topic: Authentication and best evidence rule. 3901 and 1002. During a comprehensive review of a process that needs improvement, a civil fraud trial centers around an email that allegedly contains proof of the defendant's misrepresentation. The plaintiff seeks to introduce a screenshot of the email taken on their phone rather than the original digital version. The defendant objects, citing the best rule. How should the court rule? A, the court should exclude the screenshot because the best evidence rule requires the original email. B, the court should admit the screenshot if the plaintiff can authenticate it under 3901. C, the court should allow the screenshot only if the defendant admits that the email existed and its contents are accurate. D, the court should exclude the screenshot because screenshots are inherently unreliable. Answer: B, the court should admit the screenshot if the plaintiff can authenticate it under 3901. Explanation: the best evidence rule 3002 requires an original document when its contents are in dispute. However, under 3004, secondary evidence, such as a screenshot, is admissible if the original is lost or unavailable through no fault of the proponent. Authentication under 3900 requires showing that the evidence is what it purports to be. It is incorrect because while the best evidence rule favors originals, secondary evidence can be allowed under 3004. C is incorrect because an opponent's admission is not the sole basis for admitting secondary evidence. The proponent must still authenticate it. D is incorrect because screenshots, while potentially manipulable, are not automatically unreliable. Courts routinely digital evidence if authentication is sufficient. To authenticate, the plaintiff could show metadata, testimony confirming the email's receipt, or corroborating evidence from the email provider. The court may also require additional proof of authenticity. Question 3. Topic: Character evidence and habit evidence. 404 and 406. While analyzing the root causes of sequential problems in a workplace discrimination case, the plaintiff seeks to introduce evidence that the defendant, a corporate executive, has engaged in discriminatory hiring practices in previous years. The defendant objects, arguing that this constitutes improper character evidence. Under the federal rules of evidence, how should the court rule? A, the court should exclude the evidence under 3404A because it is improper character evidence. B, the court should admit the evidence under 3406 as proof of habit. C, the court should admit the evidence if it demonstrates a pattern of behavior relevant to intent, motive, or absence of mistake under 3404B. D, the court should exclude the evidence unless the plaintiff can prove that the defendant's actions resulted in criminal charges. Answer C. The court should admit the evidence if it demonstrates the pattern of behavior relevant to intent, motive, or absence of mistake under 3404B explanation. Under 3404A, character evidence is generally inadmissible to prove that a person acted in conformity with past behavior. However, 3404B allows the use of prior acts to establish motive, opportunity, intent, preparation, knowledge, identity, absence of mistake, or lack of accident, but is incorrect because while character evidence is generally barred, 404B provides exceptions when past conduct is relevant to a key issue in the case. B is incorrect because habit evidence 3406 applies to regular automatic behavior, e.g., always stopping at a stop sign, and does not cover broad patterns of conduct like hiring discrimination. D is incorrect because prior bad acts do not need to result in criminal charges to be admissible under 404B. To be admitted, the court must determine that the prior conduct is relevant, not overly prejudicial, 3403, and directly related to the case's issues, e.g., proving the executive's intent to discriminate. Question 4. Topic: hearsay and its exceptions. 3801, 807. While analyzing the root causes of sequential problems in criminal trial, dispute arises over the admission of statement made by a key witness who is now unavailable. The prosecution seeks to introduce recorded conversation in which the defendant's former business partner, who has since passed away, explicitly stated that the defendant orchestrated fraud. Theme: the defense objects, arguing that this is inadmissible hearsay. However, the prosecution counters that the statement qualifies under the hearsay exception for statements against interest. Additionally, the prosecution argues that the statement should be admitted under the residual exception as it carries strong indicia of reliability. Which of the following is the best legal ruling on this issue? A. The statement is inadmissible hearsay because it was not made under oath in prior proceeding. B. The statement is admissible under the hearsay exception for statements against interest, as the declarant had no motive to fabricate. C. The statement is admissible under both the statement against interest exception and the residual hearsay exception. D. The statement is inadmissible because it violates the defendant's Sixth Amendment right to confrontation. Crawford v. Washington. Answer D. The statement is inadmissible because it violates the defendant's Sixth Amendment right to confrontation under Crawford v. Washington. Explanation: the statement is inadmissible under Crawford v. Washington, 2004, which held that testimonial hearsay statements are inadmissible unless the declarant is unavailable and the defendant had prior opportunity to cross-examine them. The statement in question is testimonial because it was made in context of discussing criminal wrongdoing, while 3804b(3) allows statements against interest when the declarant is unavailable. It does not override the constitutional requirement for confrontation in criminal cases. The residual exception, 3807, only applies when no other exception fits and guarantees of trustworthiness exist, but it cannot overcome confrontation clause violation. Thus, the best legal rule is that the statement must be excluded. Question 5. Topic: authentication and best evidence rule. 3901, 1008. During major transformation where existing methods of handling digital evidence are under scrutiny, civil case arises involving the authenticity of key emails. The plaintiff alleges that the defendant engaged in fraudulent misrepresentation via email communications. The only evidence presented is a set of printed copies of emails, which plaintiff asserts were received from the defendant. The defendant challenges their authenticity, claiming the emails could have been altered before being printed. The plaintiff does not have access to the original digital files, but insists that metadata analysis is unnecessary because the printouts appear legitimate. Which of the following is the best approach under the federal rules of evidence? A. The court should admit the emails as self-authenticating documents under 3902. B. The plaintiff must produce the original digital files or demonstrate why they are unavailable under the best evidence rule. C. The court should reject the defendant's challenge because the printouts appear authentic on their face. D. The printouts should be admitted if the plaintiff can produce witness who testifies they received the emails in the normal course. Answer: B. The plaintiff must produce the original digital files or demonstrate why they are unavailable under the best evidence rule. Explanation: under the best evidence rule 3002, when the contents of a document are at issue, the original must be produced unless an exception applies. A printed copy of an email does not qualify as the original if the original exists in electronic form. Furthermore, 3901 requires authentication of evidence through extrinsic proof, such as metadata analysis or testimony establishing its authenticity. The plaintiff must show either the original emails or a legitimate reason for their absence. While witness testimony under 3901b1 can support authentication, it does not override the best evidence rule requirement. Therefore, the court should require the original digital files or an adequate justification for their unavailability. Question 6. Topic: Character evidence and habit evidence. 3404-406 when developing solution that must address opposing needs in criminal prosecution for embezzlement, the defense attempts to introduce evidence that the defendant has strong reputation for honesty. The defense argues that the defendant has always been known for financial integrity, as evidenced by his history of returning overpayments to customers. Prosecution objects, asserting that character evidence is generally inadmissible. The defense counters by stating that this evidence falls under an exception allowing defendant in criminal trial to introduce character evidence related to the charges. How should the court rule? A. The evidence is admissible because criminal defendants may introduce evidence of pertinent character trait. B. The evidence is inadmissible because habit evidence is not allowed to prove person acted consistently in particular instance. C. The evidence is admissible only if the defense provides prior specific instances rather than reputation testimony. D. The evidence is inadmissible because character evidence is never allowed in criminal trials. Answer: A. The evidence is admissible because criminal defendants may introduce evidence of a pertinent character trait. Explanation: under 3404A2A, a criminal defendant may introduce evidence of a pertinent character trait. In this case, honesty is directly relevant to an embezzlement charge, making it admissible. The defense may introduce this character evidence through reputation or opinion testimony under 3400A. However, if the defendant does so, the prosecution may rebut it with its own character evidence. 3404A2A. Habit evidence under 3406 is separate and pertains to repeated, specific actions, not general character. Therefore, the court should allow the defendant's character evidence. Question 7. Topic: Scientific and expert evidence. Dober-Frye standards in high-stakes environment where multiple challenges arise in wrongful death lawsuit. The plaintiff seeks to introduce expert testimony based on controversial new blood analysis technique. The expert claims that the method can precisely determine the decedent's intoxication level at the time of death, but it has not been widely adopted in the scientific community. It moves to exclude the testimony, arguing that it lacks sufficient reliability. The jurisdiction follows the Dorbert standard for expert testimony. How should the court rule? A. The testimony should be admitted because expert witnesses are permitted to present novel scientific theories if they have specialized knowledge. B. The testimony should be excluded unless it satisfies reliability factors such as peer review and general acceptance. C. The testimony should be admitted because the expert's credentials establish sufficient reliability. D. The testimony should be excluded under the Frye standard, which requires general acceptance. Answer: B. The testimony should be excluded unless it satisfies reliability factors such as peer review and general acceptance. Explanation: under Dorbert v. Merrill Dow Pharmaceuticals, 1993, courts evaluate expert testimony based on factors such as whether the method is testable, has been peer-reviewed, has a known error rate, and is generally accepted in the field. A technique that lacks widespread acceptance and scientific validation. Likely to fail this test. Although Frye v. United States, 1923, requires general acceptance, it is not the governing standard in Dorbert jurisdictions. The court should therefore exclude the testimony unless the expert can establish its scientific reliability. Question 8. While analyzing the root causes of sequential problems in a complex fraud case, the prosecution seeks to introduce a forensic accountant's report analyzing the defendant's financial transactions. The defense objects, arguing that the report is inadmissible hearsay. The prosecution responds that the report qualifies as business record under 3803(6). However, the forensic accountant relied on third-party statements not created by the defendant's company. Which of the following is the best legal ruling? A. The report is admissible under the business records exception because the forensic accountant regularly relies on such records. B. The report is inadmissible because it contains multiple levels of hearsay that are not independently admissible. C. The report is admissible because expert reports are not considered hearsay under the federal rules of evidence. D. The report is inadmissible unless the forensic accountant testifies and establishes its reliability. Answer B. The report is inadmissible because it contains multiple levels of hearsay that are not independently admissible. Explanation. While business records are admissible under 3803(6), this exception applies only if the records were created in the ordinary course of business. If the report contains multiple levels of hearsay, each layer must be independently admissible. Because the accountant's analysis relies on bank records from a company, those statements may not qualify under the business records exception. Without an additional exception, the report is inadmissible. Question 9. During a major transformation where existing methods of handling witness credibility are under scrutiny, the defense in a criminal case seeks to introduce evidence that a prosecution witness has previously committed perjury in a different trial. The prosecution argues that this evidence is inadmissible character evidence. The defense claims it is admissible under 3608B. How should the court rule? A. The evidence is inadmissible because prior bad acts cannot be used to prove a witness's credibility. B. The evidence is admissible because prior acts of dishonesty can be inquired into on cross-examination. C. The evidence is admissible only if the previous perjury resulted in criminal conviction. D. The evidence is inadmissible because credibility evidence must be introduced through character witnesses. Answer B. The evidence is admissible because prior acts of dishonesty can be inquired into on cross-examination. Explanation. Under 3608B, specific instances of conduct relevant to a witness's character for truthfulness may be inquired into during cross-examination but cannot be proved by extrinsic evidence. If the witness denies committing perjury, the cross-examining attorney cannot introduce external evidence to prove perjury occurred. However, the attorney can question the witness about it. Question 10. When developing a solution that must address opposing needs in a civil defamation lawsuit, the plaintiff seeks to introduce the defendant's out-of-court statements to journalists. The defendant objects, arguing that the statements are hearsay. How should the court rule? A. The statements are inadmissible hearsay because they are out-of-court statements offered for their truth. B. The statements are admissible as party opponent admissions under 3801D2. C. The statements are inadmissible unless the journalist testifies to their authenticity. D. The statements are admissible only if they were made under oath. Answer B. The statements are admissible as party opponent admissions under 3801D2. Explanation. Under 3801D2, statements made by a party opponent and offered against them are not considered hearsay. Since the defendant made these statements and the plaintiff is using them against the defendant, they are admissible. Question 11. While analyzing the root causes of sequential problems in a murder trial, the prosecution introduces a dying declaration made by the victim identifying the defendant as the attacker. The defense objects, arguing that the statement is hearsay and violates the defendant's Sixth Amendment rights. What is the best ruling? A. The statement is inadmissible because it is hearsay. B. The statement is admissible under the dying declaration exception. C. The statement is inadmissible under Crawford v. Washington. D. The statement is admissible only if it was made under oath. Answer B. The statement is admissible under the dying declaration exception. Explanation. Under 3804b2, dying declarations are admissible if the declarant believed their death was imminent, although Crawford v. Washington 2004 restricts testimonial hearsay. Dying declarations are an exception to this rule. Question 12. During a major transformation where existing methods of handling forensic evidence are under scrutiny, the defense challenges the admissibility of DNA evidence collected at the crime scene. The prosecution argues that the forensic report should be admitted without live testimony from the analyst. Which ruling is correct? A. The report is admissible without testimony under the business records exception. B. The report is inadmissible unless the forensic analyst testifies. C. The report is admissible as long as the lab's supervisor vouches for its reliability. D. The report is inadmissible because forensic evidence is inherently unreliable. Answer B. The report is inadmissible unless the forensic analyst testifies. Explanation. Under Melendez-Diaz v. Massachusetts, 2009, forensic reports are testimonial and cannot be admitted unless the analyst who prepared them testifies. This ensures the defendant's right to confront witnesses. Question 13. When developing a solution that must address opposing needs in a products liability case, the plaintiff introduces evidence that the defendant manufacturer recalled a defective product after a consumer was injured. The defense objects under 3407. How should the court rule? A. The recall is admissible to prove negligence. B. The recall is admissible only to prove feasibility of precautionary measures. C. The recall is inadmissible under 3407. D. The recall is admissible as an admission of fault. Answer: C. The recall is inadmissible under 3407. Explanation: under 3407, evidence of subsequent remedial measures such as recalls is not admissible to prove negligence or culpability, but may be admitted for other purposes like feasibility. Question 14. While analyzing the root causes of sequential problems in a sexual assault trial, the prosecution seeks to introduce evidence of the defendant's prior assault charges. The defense argues that this is improper character evidence. What is the correct ruling? A. The evidence is inadmissible under 3404A. B. The evidence is admissible under 3413. C. The evidence is admissible only if the prior acts were identical to the current charges. D. The evidence is admissible only if the defendant testifies. Answer: B. The evidence is admissible under 3413. Explanation: under 3413, prior acts of sexual assault may be introduced in sexual offense cases, even if they would otherwise be barred under 3404A. Question 15. During a major transformation where existing methods of handling eyewitness testimony are under scrutiny, a witness's prior inconsistent statement is introduced at trial. The witness claims they do not recall making the statement. What is the best ruling? A. The prior statement is admissible for impeachment. B. The prior statement is inadmissible hearsay. C. The prior statement is admissible only if it was made under oath. D. The prior statement is inadmissible because the witness lacks memory. Answer: A. The prior statement is admissible for impeachment. Explanation: under 3613, prior inconsistent statements can be used to impeach a witness's credibility even if the witness does not remember making them. Question 16. While analyzing the root causes of sequential problems in a high-profile drug trafficking trial, the prosecution seeks to introduce testimony from a confidential informant, Sai, who claims the defendant admitted to importing narcotics. The defense argues that the testimony is hearsay and unreliable because the Sai received financial compensation for cooperating with law enforcement. How should the court rule? A. The testimony is inadmissible because statements by confidential informants are inherently unreliable. B. The testimony is admissible as a statement against interest under 3804B. 3. C. The testimony is admissible as a party opponent admission under 3801D2A. D. The testimony is inadmissible unless corroborated by physical evidence. Answer: C. The testimony is admissible as a party opponent admission under 3801D2A. Explanation: under 3801D2A, a party's own statement offered against them is not considered hearsay if the defendant admitted to importing narcotics. This is party opponent admission and is admissible. The fact that the Sai received compensation affects credibility but not admissibility. The defense can cross-examination to highlight bias, but it does not automatically render the testimony inadmissible. Question 17. During a major transformation where existing methods of handling documentary evidence are under scrutiny, the prosecution introduces a handwritten letter allegedly written by the defendant confessing to a crime. The defense objects, claiming the prosecution has not proven the defendant authored the letter. Which ruling is correct? A. The letter is inadmissible unless the prosecution authenticates it under 3901. B. The letter is admissible under the best evidence rule. C. The letter is inadmissible unless an eyewitness testifies to seeing the defendant write it. D. The letter is admissible as long as it was found in the defendant's home. Answer: A. The letter is inadmissible unless the prosecution authenticates it under 3901. Explanation: under 3901A, evidence must be authenticated before being admitted. The prosecution must present evidence that the letter is what they claim it to be, e.g. handwriting analysis, testimony from someone who saw the defendant write, or circumstantial evidence. The best evidence rule 3002, when the contents of a document are in question, but authentication must still occur first. Question 18. When developing a solution that must address opposing needs in a securities fraud case, the government introduces a summary of thousands of financial transactions showing the defendant engaged in fraudulent trades. The defense objects, arguing that the summary is inadmissible because the original data has not been presented. How should the court rule? A. The summary is inadmissible under the best evidence rule. B. The summary is admissible under 3-1006 as long as the original records are available for review. C. The summary is admissible as long as the prosecution claims it accurately reflects the records. D. The summary is inadmissible because it contains legal conclusions. Answer: B. The summary is admissible under 3-1006 as long as the original records are available for review. Explanation: under 3-1006, summaries of voluminous records can be admitted if the original records are available for review by the opposing party. This rule balances the need for efficiency with the right to inspect evidence. The defense can challenge the summary's accuracy, but it does not need to be excluded if underlying records exist. Question 19. While analyzing the root causes of sequential problems in a personal injury lawsuit, the plaintiff introduces a doctor's report diagnosing concussion. The defense objects, arguing that the report is hearsay because the doctor is not testifying. What is the best ruling? A. The report is admissible under the business records exception if properly authenticated. B. The report is inadmissible hearsay unless the doctor testifies. C. The report is inadmissible unless the plaintiff's lawyer wrote it. D. The report is admissible only if it was prepared at the request of the court. Answer: A. The report is admissible under the business records exception if properly authenticated. Explanation: under 3-803-6, business records, including medical records, can be admitted if they are kept in the ordinary course of business and properly authenticated. The plaintiff must show the report was made at or near the time of treatment. It was kept in the regular course of medical practice. It was not created for litigation purposes. These conditions are met. The report can be admitted even without the doctor testifying. Question 20. During a major transformation where existing methods of handling expert testimony are under scrutiny, the defense in a criminal case challenges the admissibility of a forensic psychologist's testimony. The defense argues that the expert's methods are unreliable under Daubert v. Merrill Dow Pharmaceuticals, 1993. Which of the following is the best legal standard to apply? A. The expert's testimony is admissible if it is relevant and generally accepted by the scientific community. B. The expert's testimony is admissible if it is based on reliable principles and methods. C. The expert's testimony is admissible as long as they have significant experience in the field. D. The expert's testimony is inadmissible because psychology is not hard science. Answer: B. The expert's testimony is admissible if it is based on reliable principles and methods. Explanation: under Daubert, expert testimony must be based on reliable methods, testable and subject to peer review, supported by known error rates, generally accepted within the field. Witnesses' experience alone is not enough. The court must analyze methodology to determine reliability. Question 21. When developing a solution that must address opposing needs in a breach of contract case, the plaintiff introduces an email from the defendant admitting fault. The defense objects, arguing that the email was part of settlement negotiations. How should the court rule? A. The email is admissible unless labeled confidential. B. The email is inadmissible under 3-408 if it was made during settlement talks. C. The email is admissible because it is party opponent admission. D. The email is inadmissible unless the defendant wrote it under oath. Answer: B. The email is inadmissible under 3-408 if it was made during settlement talks. Explanation: under 3-408, statements made during settlement negotiations cannot be used as evidence to prove liability. This rule encourages parties to settle without fear that their words will be used against them later. Question 22. While analyzing the root causes of sequential problems in a domestic violence case, the prosecution seeks to introduce a 911 call in which the victim identified the defendant. The defense objects on confrontation clause grounds. What is the correct ruling? A. The court is inadmissible because it is hearsay. B. The court is admissible because it is a present sense impression. C. The court is admissible if it was made to seek help during an ongoing emergency. D. The court is inadmissible unless the victim testifies. Answer: C. The call is admissible if it was made to seek help during an ongoing emergency. Explanation: under Davis v. Washington, 2006, 911 calls are not testimonial and thus admissible if made during an ongoing emergency. If the call was made to seek help rather than provide evidence, the confrontation clause does not apply. Question 23. While analyzing the root causes of sequential problems in a criminal fraud case, the prosecution seeks to introduce statements made by the defendant to an undercover FBI agent posing as a business partner. The defense objects arguing that the statements were obtained through deception and should be excluded. How should the court rule? A. The statements are inadmissible because they were obtained through deception. B. The statements are admissible because they are an opposing party's statement under 3801 D2A. C. The statements are inadmissible unless the defendant waived their Miranda rights. D. The statements are admissible only if the FBI agent testifies. Answer: B. The statements are admissible because they are an opposing party's statement under 3801 D2A. Explanation: under 3801 D2A, defendant's own statement offered against them is not hearsay. The fact that the statement was made to an undercover agent does not make it inadmissible. Miranda warnings are required only for custodial interrogations, not voluntary conversations. Question 24. During a major transformation where existing methods of handling digital evidence are under scrutiny, the prosecution introduces text messages retrieved from the defendant's phone, which contain threats against the victim. The defense argues that the texts are unauthenticated and could have been sent by someone else. What is the best ruling? A. The texts are inadmissible unless forensic analysis proves the defendant sent them. B. The texts are admissible under 3901 if there is circumstantial evidence linking them to the defendant. C. The texts are inadmissible because electronic communications require direct eyewitness testimony. D. The texts are admissible only if the victim received them. Answer: B. The texts are admissible under 3901 if there is circumstantial evidence linking them to the defendant. Explanation: under 3901, electronic messages must be authenticated before admission. Authentication can be established through circumstantial evidence, such as the phone belonged to the defendant. The content of the messages references personal knowledge only the defendant would have. Metadata or timestamp support authenticity. Direct forensic proof is not always necessary. Question 25. When developing a solution that must address opposing needs in a medical malpractice lawsuit, the defense seeks to introduce testimony from an expert witness regarding the standard of care. The plaintiff objects, arguing that the expert's methodology is unreliable under Daubert. How should the court analyze the expert's testimony? A. The court should exclude it unless the expert's methods are generally accepted in the medical field. B. The court should allow it if the expert is well credentialed regardless of methodology. C. The court should evaluate whether the expert's methods are reliable and based on scientific principles. D. The court should exclude it if the expert has testified in prior similar cases. Answer: C. The court should evaluate whether the expert's methods are reliable and based on scientific principles. Explanation: under Daubert v. Merrill Dow Pharmaceuticals, 1993, court must ensure expert testimony is based on reliable scientific methodology, not just general acceptance. Daubert overruled the Frye standard. Factors include whether the method is testable, whether it has been peer-reviewed, whether it has known merit. Well-credentialed expert must still use reliable methods. Question 26. While analyzing the root causes of sequential problems in a defamation lawsuit, the plaintiff introduces a newspaper article containing false claims about their character. The defense objects arguing that the article is hearsay. What is the correct ruling? A. The article is inadmissible hearsay unless the journalist testifies to its accuracy. B. The article is admissible under 3803(8) as a public record. C. The article is inadmissible unless the plaintiff can prove actual malice. D. The article is inadmissible hearsay because it is an out-of-court statement offered for the truth of the matter asserted. Answer: D. The article is inadmissible hearsay because it is an out-of-court statement offered for the truth of the matter asserted. Explanation: a newspaper article is hearsay under 3801 C because it contains out-of-court statements offered for their truth. It does not fall under 3803 A public records exception because news reports are not government records. Even if the plaintiff can prove malice, the article itself cannot be used as evidence of its own truth unless a hearsay exception applies. Question 27. During a major transformation where existing methods of handling eyewitness testimony are under scrutiny, a defense attorney seeks to exclude an eyewitness's identification of the defendant. The attorney argues that the police lineup was suggestive. Which legal standard should the court apply? A. The lineup must be excluded if it was suggestive and led to an unreliable identification. B. The lineup is admissible if the witness is confident in their identification. C. The lineup is admissible unless the defense can prove intentional misconduct. D. The lineup must be excluded if police officers conducted it. Answer A. The lineup must be excluded if it was suggestive and led to an unreliable identification. Explanation. Under Neal v. Biggers 1972 and Manson v. Brathwaite 1977, courts evaluate eyewitness identifications by considering whether the procedure was unduly suggestive, whether the identification was reliable despite suggestiveness. If suggestiveness created a high likelihood of misidentification, the evidence excluded. Confidence alone does not guarantee accuracy. Question 28. When developing a solution that must address opposing needs in a breach of contract case, the plaintiff seeks to introduce a recorded phone call of the defendant admitting to wrongdoing. The defense objects arguing that the recording violates wiretap laws. How should the court rule? A. The recording is inadmissible unless both parties consented to the recording. B. The recording is admissible if at least one party consented, depending on state law. C. The recording is inadmissible unless the defendant was under criminal investigation. D. The recording is admissible only if it was made by law enforcement. Answer B. The recording is admissible if at least one party consented, depending on state law. Explanation. Wiretap laws vary by state. One party consent. States allow recordings if one party to the conversation consents. Two-party consent. States require all parties to consent. If the recording was made legally, it is admissible as an opposing party's statement. 3801d2. Question 29. While analyzing the root causes of sequential problems in a murder trial, the prosecution seeks to introduce the victim's dying declaration identifying the defendant. The defense objects, arguing that the statement is inadmissible hearsay. What is the best ruling? A. The statement is inadmissible unless the victim was under oath. B. The statement is admissible under 3804. B2 is dying declaration. C. The statement is inadmissible because the victim cannot be cross-examined. D. The statement is admissible only if the victim survived for at least 24 hours after making it. Answer B. The statement is admissible under 3804b2 as a dying declaration. Explanation. Under 3804b2, a dying declaration is admissible if the statement concerns the cause or circumstances of death. The declarant believed death was imminent. Dying declarations are an exception to hearsay and do not require cross-examination. Question 30. During a major transformation where existing methods of handling business records are under scrutiny, the defense seeks to introduce corporate emails proving the defendant followed company policies. The prosecution objects, arguing that the emails are hearsay. How should the court rule? A. The emails are admissible under the business records exception if properly authenticated. B. The emails are inadmissible unless they were written by the defendant. C. The emails are inadmissible unless they were created specifically for trial. D. The emails are admissible only if the defendant testifies. Answer A. The emails are admissible under the business records exception if properly authenticated. Explanation. Under 3803(6), business records are admissible if kept in the ordinary course of business and properly authenticated. Corporate emails can qualify if they were made at or near the time of the event. They were part of routine business operations.